Hello, everyone. My name is Paula Edgar, and I am the president of the Metropolitan Black Bar Association, and I'm thanking you for joining us today for MBBA Learns, Common Mistakes in Estate Planning. This is going to be the first webinar we're doing for the new bar year, with many to come, and I'm going to walk you through a little bit of information about the Metropolitan Black Bar Association before we get started, and I hand the webinar over to our panelists. So, as I mentioned, my name is Paula Edgar. In addition to being the president of the MBBA, I'm also the owner of my own consulting company where I do speaking, coaching, and consulting. And I have my own information there, so you can connect with me either via MBBA or through my website, paulaedgar.com. This is going to be the second year of my term. We have a 2-year term with the Metropolitan Black Bar Association, and we're excited. We had a lot of great things happen last year, and we're excited about the things that are going to happen as we go forward. So, under the first year, we talked about the 4 Ps. I like the letter P. My name starts with the letter P. And we had pipeline, professional development, presence, and partnerships as the theme of our bar year, with some of these things being what we worked on, which is we had sponsorships, scholarships, backpack giveaways, which we just finished our most recent one. We instituted a lot of more professional development. We were much more present in terms of social media, as well as being present in all the 5 boroughs. And we partnered with organizations and initiatives in order to advance the needs of our members as well as our community. This year, we are going to continue the work with what I'm calling impact. And impact starts with I for innovation, which will be innovating and doing lots of new different things to continue the engagement with the organization. We will be encouraging mentoring. Partnership will continue. We'll partner with organizations, and we'll also continue to use that double entendre of having our members who would like to be partners. We're helping in that set as well. We will be much more present in the advocacy space. As Black lawyers, obviously, we want to utilize the skill set that we have learned in law school and in practice to help. And that helping piece comes with kind of engaging with our community. As I mentioned, we just finished doing a backpack giveaway, and this past weekend we gave out over 1,200 backpacks in each of the 5 boroughs. And then finally, training. Training is our take on the other P for professional development, where we'll be doing much more training and professional development for our members in order to continue your trajectory, whatever that might be as an attorney or supporter of the legal profession. But we need your help. We have standing committees and also sections that can use some energy, your energy. And so if you are not already, please do reach out to us to join. And by join, I also mean joining the MBBA. If you are currently one of our supporters but not a member, I do encourage you to actually join. It's important for us in terms of maintaining our status as an organization. We need to have membership, but we also want to have your engagement on multiple ways, not just in your dues, but in your coming to events and speaking on panels, doing things like that. So please do join and engage. If you haven't visited our website, please do. It's wonderful and has a lot of information about the organization. In terms of upcoming events, there'll be several, but for the first of the bar year in person is our MBBA membership meeting, which will be held on September 12th at Sullivan and Cromwell, continuing the professional development piece that we've instituted at our membership meetings. We will have a half-credit CLE on conducting the perfect opening statement, preparation and delivery. We thought it would be a good topic, given that folks who are not litigators can also learn about best practices for speaking in front of groups. And then you'll probably never hear me speak about anything if I don't talk to you about my favorite event of the year, and it should be yours as well, which is our gala. And so here's our save the date. Our gala is going to be on May 18th, 2018. Tickets will be on sale very soon. But that's the date, that's the hashtag. We are going to have a really fun time, and I look forward to seeing you there. As always, if you have any questions about the MBBA, you can reach out to us at info@mbbanyc.org, and you can reach out to me directly at president@mbbanyc.org, in which you receive several emails from me about this webinar. Speaking of the webinar, our presenters are going to present and then take questions at the end. There is a question asking space in the dashboard that you're using for the webinar, so you can use that to ask questions, and I will, at the last 10 minutes, I will be addressing the questions that you have raised to the speakers. With that, I would like to let you know who will be speaking. Gregory Anderson, who is a financial services professional agent at New York Life Insurance, and Lillie Nkenchor, who is the CVP of National Advanced Planning Consultant and African American Markets at New York Life as well. So they will be our speakers. And with that, Lillie and Gregory, I leave it to you.
Thank you, Paula. And next slide. So as Paula mentioned, I'm Gregory Anderson. I'm an agent and financial services professional with New York Life Insurance and New York Life Securities. So good afternoon, everyone. And first, I'd like to thank Paula for providing us with the opportunity to present to the MBBA and all who are with us. I want to say thank you for participating. We have a lot to cover, so in the interest of time, I'm going to dispense with the New York Life commercial and introduce my colleague, Lillie Nkenchor, who is a corporate vice president and with our advanced planning group, and we are proud to say a 2017 National Bar Association 40 Under 40 award recipient. I would like Lillie to just take a minute to describe some of her activities with our advanced planning group, as she is an invaluable resource to all of us here at New York Life. Lillie?
Thank you, Greg, and thank you, Paula, and thank you to all of those in my MBBA family who have dialed in. I really appreciate you all being here. Just really quickly about what I do. I think everyone understands the basic uses of our products, life insurance, mutual funds, annuities, things of that nature. A lot of people just think, okay, you know, I get enough life insurance to pay burial expenses or perhaps end-of-life medical bills, so on and so forth. I get a term policy through my job. Not many persons understand that those same instruments can be used in an advanced setting, meaning this can be used to defer taxes. It can be used to pay your taxes. It can be used to supplement your retirement that you've set up either through your employer or something you've set up for yourself as an independent business owner. So our products can be used in more than the typical ways that are, you know, addressed around the water cooler, if you will. And so my role is to go out to my affluent clients. And by affluent, we're typically talking of persons who have assets, investable liquid assets of at least $200,000, $250,000. They may be executives, they may be business owners. That doesn't really matter. It's just their ability to invest is what we use to consider them wealthy. And so my role is to meet with our affluent clients and discuss these advanced uses of our products and how it rolls into their estate plan, their business plan, or even their retirement plan. And I do that specifically for the African American market, but it's something that I've been doing for about 10 years at this point, and I go across the country doing it, but I do focus on our market here at New York Life. Next slide.
So all of you understand the importance of disclaimers. So I just want to say that you should know that while we are here to educate you on some important concepts, none of the strategies we discuss should be implemented without first seeking and relying upon the advice of your own attorneys and tax advisors with respect to your own particular situation. Next slide, please. So this is basically the foundation of the time we're going to spend together, and so I'll just read this slide. It is not uncommon for there to be significant and costly mistakes in the estate and wealth transfer plans of affluent Americans. Most of these estate owners do not understand the nature of the mistakes, their consequences, or the fact that solutions do exist. Next slide, please. This presentation is intended to help you uncover wealth transfer mistakes in your current estate plan, or if you're in the process of building a plan, how to avoid some of these mistakes. Our presentation is also intended to help establish an action plan for identifying and implementing common solutions. So, Lillie, what would you say are the most common mistakes in estate planning? Next slide.
Well, great question. So I want to level set and say this to everyone. Estate planning is a word that's used so often that people fool themselves into thinking they understand what it means. Some people say, oh, that's just a will, or oh, that's a trust, or that's a beneficiary designation, or that doesn't apply to me because I don't have anything to give anyone. I want to say that estate planning is for everyone. Everyone has an estate. The estate might be worth $100, $100,000, or $100 million. The value doesn't have anything to do with the fact that it exists. And I love to tell our clients, if you are someone who cares about who gets your stuff, when they get your stuff, and how they get your stuff, then you're a person who cares about estate planning. Unfortunately, there are a lot of mistakes that are made in the process. Sometimes it's just because people are unaware, even though they had really good intentions. And so my role here today is to share with you the top 10 common mistakes that we see here in the industry. The first being incapacity. Then there's distribution, documents, ownership, tax-free transfers, cost-efficient transfers, qualified plans, charities funding, and then we'll leave number 10 as a mystery. So if we can go to the next slide and get into incapacity, we can talk about the first issue that I see in my field. And so typically incapacity just basically means this person does not have the faculties to make decisions. Is it because they have had an accident, Alzheimer's, age, injury, birth defects? It really doesn't matter. What matters is this person, from a legal perspective, doesn't have the entire wherewithal to sign documents, to say yes, to say no, to open accounts, to do any of that stuff. And so a lot of times I like to tell persons, you are more likely to become disabled before you pass away. And so a lot of people are concerned about death to a certain extent, but not many people are concerned about disability and being incapacitated. I don't want to be doom and gloom. Unfortunately, some of that is associated with the role that I have, but I see it all the time. And you're more likely to get into a car accident or suffer from dementia or something like that that makes you incapacitated. So if we move to the next slide, we'll see that what that creates is a situation where people who cannot make decisions on their behalf are kind of left lingering from a legal perspective, because if you're incapacitated and you have not yet given the authority to someone else to make those decisions for you, it slows down the process. So when we go to the next slide, we'll see that one of the many ways that you can solve that issue is by just having the right types of documents. I can't make this decision on my behalf, so I'm going to entrust you. Whoever you are, you could be my spouse, you could be my child, you could be my best friend, you could be my attorney, you could be my godmother. You doesn't matter. The point is I've appointed a you to make those decisions for me. And so one is a durable power of attorney. And essentially this says, listen, I trust you so much, Greg, that at this moment, I'm going to sign over a document to you that says you have the right to make decisions on my behalf. Financial decisions more typically than not. And the durable is what's really important here, because that means I'm giving Greg that power immediately. He doesn't have to wait until I become incapacitated. I give him that authority now, and he could literally go to my ATM at Bank of America and withdraw money and have the authority to do that within reason, of course. But I'm giving him, well, not even within reason, I'm giving him that entitlement. The only time I can limit it is if I have a springing power of attorney, which you don't see very often, because springing means I have to decide, okay, now I'm incapacitated and now I want you to have that authority. But if I'm incapacitated, I really can't even make that decision at that time. So the safer bet is a durable power of attorney. Living will. Greg, if something happens to me and the doctors don't think I will make it, the brain injury is too severe, I'm going to live in a vegetative state, I don't want to live like that, or I do want to live like that, I give Greg the authority to make that decision when the doctors come to him and say, what do you want us to do? Healthcare proxy. which is, again, similar to the durable power of attorney, but it's for medical issues. I'm giving him the right to speak to my doctors about my issues. I'm giving him the right to make those types of medical decisions. So basically all medical decisions minus life or death. Life or death is more associated with the living will, and healthcare proxy is for everything else. Living trust. You will hear this be called living trust, family trust, revocable family trust, revocable living trust, all sorts of terms. But what a living trust does is it allows you to control from the grave. It allows you to put the most general or even the most nuanced of instructions. I have read trusts from my clients who said, I give this to my granddaughter, but only if she graduates from Rutgers University. It can be that specific. And so this allows you to, back to what I said, if you're someone who cares about who gets your stuff, when they get your stuff, how they get your stuff, a living trust allows you to take that to the next level and be very specific in your instructions. And a lot of times my clients will ask me, well, what's the difference between a trust and a will? Can't I just have a will and have all of this taken care of? I like to say that a will is a safety net. It's the bottom line of defense in case everything else doesn't work out. The will act as a catch-all, a safety net that catches those things that don't know what to do. But it's still advantageous to have a trust. For one, it's a private document. A trust is a private document. I created, I have a witness, I signed it, the whole bit, and now it's private. No one else has to see who I've left things to. They don't have to see my net worth, any of that type of stuff. A will is public. It needs to go through the court process. So any one of us on this phone can go to our local courts and pull up our neighbor's wills. A trust is private. A will is public. A trust allows you to give very specific instructions. So when I said earlier about the client who is giving something to her granddaughter only if she graduates from Rutgers, you're more likely to see those instructions in a trust than in a will. Lastly, a will needs to go through the probate process, which is basically the judge looking through your documents and saying, is this valid? Were you in your right mind when you made this? Was there a witness here? All the people who are inside this document, are they alive? Where are they? Can we find them? That's a costly and timely process. The will has to go through that process, but a trust does not. So those are the three main differences between a trust and a will. Next slide, please. So we're done with incapacity. Let's go to distribution. The next slide will tell us this honestly is the most egregious mistake that I've seen. And I don't care if someone is worth $5 or $500,000. Distribution issues come up all the time because a lot of persons are concerned with accumulating wealth, accumulate. How can I get more? How can I get more? How can I save more? And then they do a poor job figuring out how do you distribute it to the next person? How do you get it to them on a timely, tax advantage basis? Next slide. So this is what I want us to consider when we're talking about distribution. I want us to think about how can we make sure that this gets to the right person at the right time. Because what the two main mistakes that you'll see with distribution is you've given it to someone, you've given a lump sum of assets to someone who's financially immature, and that includes someone who is just a minor, and so they shouldn't be making those types of decisions. It also includes grown people who shouldn't even be making those decisions, and it also includes persons who maybe have some type of substance abuse problem and would squander that money pretty quickly. And then secondly, speaking of squandering, that's the second issue. People sometimes, money that's left to your heirs, money that could honestly be invested really well and last at least half of their lifetime, I've seen be squandered anywhere between 5 and 10 years because money is, the ability to manage money is a gift. Not a gift, it's a skill. You cannot just give someone $100,000 and think that their life will be the same. Their ability to manage the money is what's going to keep that money in the family. It's the reason why lottery winners, go broke within 10 years because they just don't know how to handle the money. So when I run into families, the number one concern is distribution concern. How do I make sure this doesn't go to my sister who has an alcohol problem? How do I make sure this doesn't go to my niece before she's age 25 because I don't believe she's mature yet? And how do I make sure that this goes to my mom or my dad and their creditors do not have access to it? The golden rule, if you own it, meaning it's in your name, they can seize it. So if I give a gift to Greg of $100,000 and Greg owes Macy's will say, oh, look at that, Greg. You just came into $100,000. You've been buying nice suits for us. You owe us $70,000. We'll take that. Thank you. And now that $100,000 gift that was made for my friend Greg has now been squandered and is now a $30,000 gift. So when you think about how your assets are to be distributed, think, is this person mature enough to handle this? And how do I make sure, even if this person is mature, it doesn't end up in the wrong hands? And when we go to the next slide, Paula, we'll see some ways that we can fix that. How do we make sure that this isn't in the wrong hands, whether it's a creditor or an ex-spouse? So outright distributions also create another issue. So we have, they're not financially mature. They have creditors that will have access to their money. And the last thing is it's part of their estate. Now, to be fair, most persons in America will not have an estate tax. You only are subject to an estate tax if we tally up everything that you own and it's worth more than $5.49 million. Most persons cannot say that they will fall into that category at any time in their life. But there are also a lot of people who will fall into that category. And again, remember that the U.S. is taxing your worldwide assets. So if you have a piece of property in the Bahamas, they count that. You have a business in California, but you live in New York, they count that. You and your sister have a timeshare in Paris, they count that. They're looking at the totality of your worldwide assets to see if it falls above that $5.49 million. So let's say you're in that situation, and I leave you a gift outright. I give it to Greg. Greg is $7 million, and he's my best friend, and I want to leave him my Miami Beach property that's worth $800,000. I've now put Greg in a situation where he's not worth $7 million. He's worth $7.8 million, and I've caused his estate tax to be larger. Because, again, now that it's in his name, it can be accessed, it can be seized by creditors, and it can be taxed by the federal government. So when you think about distributing assets, be mindful of the recipient's estate tax issue. Are they already wealthy and you're about to give them a well-meaning gift that actually causes them to pay taxes? You might be. So some of the solutions on the next slide are a way to give them access and have them get it, but without creating additional issues for them. Actually, we'll go to the next slide, Paula, because I've pretty much addressed this slide. Is there a better way to give? If you give it outright on the left-hand side, that means you've exposed that money to creditors, you've exposed it to divorce, you've made it part of their estate. So if their estate is large enough, you've created an estate tax for them, maybe even a GST, which is a generation skipping tax, and which may result in fewer assets actually being available to the recipient. But on the right-hand side, if you leave it in a trust where they use the assets, they don't have to own it. Remember, if I give Greg a home, my Miami Beach property, he doesn't actually have to own it, right? It doesn't have to be in his name. He just likes the fact that he can go there whenever he feels like it, fully furnished, on the beach, mojitos, house parties, the whole bit. So if I allow him to use it, it's the same thing as him owning it. So what I can do is I can put it in a trust so that he can use it versus owning it. Now, because it's not in his name, no creditors can come after it. Now that it's not in his name, if he gets a divorce, his spouse can't say, I want half of that. Now that it's not in his name, it's not part of his estate. That way, he can use it and have all the glory to this beachfront property in Miami and not have to worry about Macy's coming after him, an ex-spouse coming after him, or it increasing the size of his estate and me creating a tax bill for himself, or a greater tax bill for him. Next slide, please. What's our next one? Documents. Next slide. Documents is the easiest thing to fix, but We rarely remember to do it. And so documents really is all about having your will. A lot of persons don't have a will, or they have a super outdated will. So let's talk about for those who don't have a will at all. And I know that it's tough. I've been doing this work for 10 years, and the end of 2016, I was finally able to convince my parents to get a will. So how crazy is that I do this for a living and I couldn't get my own parents to do it? So I get it. We're talking about a time when you won't be here. No one likes to think or talk about that. It's very uncomfortable. But the relief that my parents felt after they did it reassured me that what I'm doing is important, and what you all should be doing is important as well. A will. A lot of times your local estate planning attorney will create an estate planning packet. It'll have a will, it'll have power of attorneys, it'll have healthcare proxies, it'll have a revocable living trust, a living trust, family trust, all the same thing. It's usually a 4 or 5 packet document, all put together and prepared as one. That is the basic estate planning kit that all persons should have, regardless of the size, the value of their estate. So a lot of persons don't have that. That's the first thing. And the problem with that is if you don't have one, the state that you live in will give it to you. As simple as that. So most of the time, most states will say if you're married, we'll give it all to your spouse. Or if you're married and you have kids, we'll split it, usually a 50-50 split, sometimes a 70-30 split between your spouse and your children. And that's it. They're not taking into consideration your charities, your alma maters, your fraternities or sororities. They don't care about, you had the intention to give it to your godchild, or you wanted to do something for your church. None of that matters to the state. The state is just trying to make sure that your immediate family doesn't have to fall into a state of welfare. And so they will only take care of your spouse and your children. A lot of people have a lot of people they want to care for, and it's not just that. So a state-given will might not be the best thing for your family. Another thing to keep in mind is documents can be very simple, or they can be a little bit more tax efficient. And on the next slide, we'll see what we mean by that. A simple will is something I would refer to as kind of an I love you will. I love you so much, just have everything. I don't even give any specific instructions. I love Greg so much. Greg, have the house, have the cars, have the jewelry, have the cash, have the checking, have the savings, have everything from the top of the roof to the basement. And that's most persons' will. Husband leaves all assets to wife or vice versa, and after the second spouse dies, whatever happens to be left over, if anything, goes to the children. Next slide. That's a simple will. It works a good amount of times depending upon what you have, but there are ways where you can be more strategic and be more tax efficient. So here, really quickly, we have the exemptions and the tax rates. Again, like I said earlier, most persons will not fall into this situation. Nonetheless, I want to share with all of you because I love doing it. I love sharing the knowledge with all of you. And you never know, you may be wealthy one day, wealthy in terms of above 5.49. So the estate tax exemption is 5.49. The gift is 5.49. The GST, generation skipping tax, also 5.49. And the max tax rate is 40%. So what does that mean? That means for estate tax purposes, if you fall above that, if you are above that 5.49 million, we're going to tax the excess at 40%. So let's say in Greg's situation, he's worth $7 million. The first 5.49 is free and clear. The government is not going to track that down and try to tax it. The excess of 5.49, which is 1.5 in this situation, is going to be taxed, and it's going to be taxed at approximately 40%. Same thing with giving. Greg can give up to $5.49 million during his entire lifetime and never have to pay gift taxes. And that's another thing. People don't understand gift taxes will actually be borne by the person who's making the gift. I mean, if someone gave you a gift and said, here's a gift, but you have to pay the taxes on it, that doesn't really feel like a gift, right? You feel like, thanks. But so in order for that to really make sense, it's the person who's giving the gift that pays the tax on it if there is an applicable tax. And so in my situation with Greg, if Greg wants to give, the government is saying, go, be altruistic, give as much as you want. But after 5.49 million, you're going to have to pay the gift tax on what you give, and you'll be taxed at that at 40%. The highest individual income tax rate right now is 39.6%. capital gains tax rate is 20%. Most persons are still at the 15%, that's 1-5. But for those of you who earn an income that's considerably high, typically $350,000, $380,000 or more, that's when you'll be subject to the 20% capital gains rate. Next slide. So back to the wills. So we had a simple will, which is I love you so much, just take everything. I'm not going to give you any instructions. And now we have a more tax-efficient will, which says I love you so much, I'm actually going to help you out here. I am not going to give you so much stuff that I create a larger tax bill for you when you die, okay? So in our situation, husband says the portion that I can save from taxes, the 5.49, I'm going to put that in a credit shelter trust. I won't bore you with the details with that. I'll put that in a credit shelter trust, and anything in excess of that, I give that to my wife. So wife now has money that has been given directly to her, and she has access. She can use the stuff, use the dollars that are inside the credit shelter trust, but exclude it from her estate. Why? Because she doesn't own it. Golden rule, if you don't own it, they can't access it, they can't seize it, and they cannot tax it. So what husband has done for wife here is say, listen, there's a portion of money that I'm going to give right out to you. It's all yours. You own it. It does increase the size of your estate. But there'll be another pot of money that's not part of your estate. You get to use it and play with it and, you know, have fun with it. But I'm helping you out because it's not going to be part of your estate, and therefore it won't make your tax bill bigger. And, of course, once we both pass away, whatever happens to be left over will pass to the children. So you have a simple, I love you will, have everything in the house, I don't really care. And then you have a more tax-efficient plan, which is, I'm going to help you. You have access to some of this, but I won't include it in your estate so that I don't make the bill larger for you. Next slide, please. Next thing, ownership. Next slide. Ownership is all about who is going to get your stuff after you've passed away. And you can title things on deeds to make sure that that's done efficiently, quickly, and without involvement from the court. And typically you'll see people have their assets titled jointly with rights of survivorship, So what that means is Greg and I own a piece of property, 50% owners. The Miami Beach, let's go back to the Miami Beach property. We own it jointly with rights of survivorship. As soon as I die, that property automatically belongs to Greg. He doesn't need to fight anybody. He doesn't need to do anything. That is now his piece of property. Even if I put in a will somewhere else that it goes to my sister, the document that's titled jointly with rights of survivorship trumps the will. It trumps the will. It trumps a trust. It trumps a conversation I may have had at the bar, giving stuff away because I had too much tequila. That is the leading document. So if you want to make absolute sure that your asset will pass automatically to someone else, it will be owned jointly with rights of survivorship. You see that mostly in husbands in spousal context, but it can be owned outside of the non-spousal context as well. Another thing to keep in mind is if you have a business, a lot of persons, especially in the New York area, love real estate. We love real estate, investment property, rental income property, so on and so forth. A lot of persons make the mistake by owning that in their name versus owning it in an LLC. And so I always encourage my clients to lean towards an LLC just for the creditor protection, or an S Corp as well for the creditor protection. That allows you to be able to run the business, have access to the funds, so on and so forth. But if someone sues you personally, they won't be able to have access to the real estate property. Also, trust and pay on death accounts are a good way to designate ownership for bank accounts. A lot of times when persons pass away, their family members can't have access to that Bank of America checking account, that savings account, that safety deposit box at the local credit union, because there's no one else who's named on that document. So when it comes to ownership, think, who do I want to have access to this at my death, and what contract would I need to put their name on so that they can immediately have access and don't have to fight with random shady family members that come out of nowhere, or they don't have to fight with the bank, or they don't have to fight with the court. Next slide, please. So these are examples of, because we're at a life insurance company, I'll just use this. These are the types of policies people will have: a $500,000, $1 million, whole life, group term, the whole bit. Next advancement. And typically people will just own that by themselves in their own name. But one of the things I advocate is putting it inside of a trust. And here we have an irrevocable life insurance trust, which is basically just an irrevocable trust that allows the trustee to buy life insurance on the grantor. So an alternative is, instead of you owning it personally and having it be subject to your creditors and having it be included in your estate and so on and so forth, have it inside of a trust so that you can have more control and make sure that it goes to the right person at the right time. Next slide, please. Yep, we can go to the next one too. So next mistake, we've done incapacity, we've done distribution, making sure that it goes to the right people at the right time, documents, ownership. Now let's do tax-free transfers. Next slide. And admittedly, this is more valuable for those who exceed that 5.49 million exemption, but again, never know. Let's talk about it. Most affluent persons don't realize that they can make tax-free transfers while they're alive. So there are two ways to do it. Remember earlier I said that Greg has $5.49 million to give? That's over his entire lifetime. So if he gave Paula $1 million today, tomorrow he only has $5.49 million. And if he gave $1 million next year, the following year he only has $3.49. So it's the totality of your lifetime. You have $5.49 million. But you have a second bucket, and that second bucket is called the annual gift, and that's $14,000 per year to as many people as you want. So I'm looking at the phone lines, and it looks like we have 18 persons. I, Lillie Nkenchor, can give $14,000 to each of the 18 persons on this phone and never have to pay any gift tax. And the reason that's good is because if I'm worth a lot of money and I want to really make sure that I'm not hit with that 40% gift tax, estate tax that's waiting for me, I need to start moving things out of my name. I need to start giving things away. But I don't want to have to pay a tax to do that. If I use my annual, I can give away $14,000 every year. If I'm married, my husband and I, or my spouse and I, can combine forces and give $28,000 every year as a couple. And that's just a way to slowly but surely get assets out of your name so that by the time we pass away, we don't have an estate tax liability, or we've decreased the estate tax liability. Next slide. So that's what we mean by tax-free transfers, putting things in other person's name and not having to pay taxes. You can use your annual exclusion of $14,000, or you can use your lifetime of $5.49. Cost-efficient tax transfers. Next slide. Again, this is another area that mostly applies to persons who are in excess or worth in excess of the $5.49 million. So how do we make the most of these types of transfers? Next slide. Generally, two ways: minority interest and marketability interest discount. So think about it this way. The government is trying to tax me on my transfer. So they're really watching me and saying, how much is that Miami property that Lillie wants to give to Greg? When we pull it up on Zillow or Zillow, can't recall how it's pronounced, or we go to the Clark County office, we think that property is worth $800,000. I might say, actually, it's only worth $400,000, and therefore I should be taxed on $400,000 and not $800,000. So when we think about cost-efficient transfers, it's all a way for me, who's giving the asset away, to find a way to discount this so that the tax is applied to the discounted price, not the fair market value price. So next slide, minority interest. You'll typically see these in a, you can move forward as well with the next slide. You'll typically see this in a situation with a business owner. So let's say I own a business and I have a child. My child's name is Jerry. Jerry works at the business. I'm 100% owner. But I want to start to give some of the value to Jerry, my son, so that I can decrease the size of my estate. I might say, Jerry, listen, I'm going to transfer 10% of this $1 million business to you. That way I will own $900,000 and you will own $100,000. But when I report this to the IRS, I'm not going to say that I gave a $100,000 gift. I'm going to try to get a discount. I'm going to try to go for a 25 to 30% discount and claim that I made a $75,000 or a $70,000 gift instead. And how am I going to rationalize that to the IRS? I'm going to say I gave my son Jerry a minority gift, a minority interest. And what does that mean? He really doesn't have any say-so in the business operations of this, I'm trying to think what kind of business this is, cupcake company. He's 10% owner, but he doesn't run any of the day-to-day operations. He cannot make any decisions. So yeah, he owns 10%, but that 10% is really worth kind of more like 7% because he doesn't have that much authority. Same thing with marketability. If we go to the next, well, let's stay here, sorry. Same thing with marketability. I've given Jerry 10%, but when it's time for him to sell it, no one wants his 10%. Who's going to buy 10% of a business unless they want to be a passive, silent investor of a business where they have no control? So now I can take an additional discount and say not only is it minority interest because he doesn't have that much say-so in the business, but for marketability purposes, when it's time for him to sell, he's going to have a really hard time selling this thing that is almost pretty much worthless because it doesn't come with voting rights. It doesn't come with control. It doesn't come with access. And so minority discounts and marketability discounts are the two ways we can try to decrease the value of a gift. Next slide. Qualified plans. Next slide. Everyone has this. 401k plans, 403b plans, all the qualified plans that they take out of your take out of your check tax-free, and then you pay the tax later. Next slide. Wonderful plan. Wonderful, wonderful plan. Terrible, terrible plan to leave to someone at death. Always think about this. The reason that the government has created these types of plans is to make sure during your retirement, you're good to go. They don't want you destitute. It's a public policy reason. We want you to be able to kind of enjoy the fruits of your labor, if you will. But it's not the best asset to leave to someone when you pass away. Why? Because of all of the taxes that will be waiting for that person when they inherit it. Now, this doesn't apply for the most part if you're leaving this to your spouse. But there are a lot of clients who have their children, spouse and children, as the beneficiaries of their qualified plans. And so if that's you, listen up. Unless you don't care. Listen, I've run into some clients who said, I made it on my own. My kids can make it on their own, too. I don't need to leave them everything. But what I hear when someone says is, I don't want to spoil my kids. I don't want to give my kids so much money that they squander it. And instead of just not giving them anything, let's just give it to them on a more tax-favorable basis. So here, let's take the example of a pension. Let's say you have $1, and let's say you have an estate tax. So you're already losing 40 cents of that dollar because of the estate tax. Now you have 60 cents. Now you have IRD, which is income in respect of a decedent. That means these are the taxes that you should have paid, but because you died, someone else has to pay it. There's 21 cents. So that pension dollar is now 39 cents to your heirs. If you were alive, you would have had, the whole pension dollar or most of it. But now that you've died and left it to someone else who's not a spouse, they only have 39 cents. And that's what I mean, next slide, when I say that qualified plans are great to live on, but not great to pass on to someone else. So try to think of some distribution strategies that will be better. One, stretch it out. Look to your qualified plans to see if there is a stretch option or a lifetime option whereby you leave it to someone and they can elect to stretch it out over their lifetime so they can get more of the money as opposed to being forced to pay the taxes all at once. Early withdrawals gifted to a trust. Think about strategies that will allow you to take money out of your qualified plans and put it inside of a trust and have it grow tax-deferred in a tax-deferred vehicle in the trust instead of just giving it outright to someone. And then also think of some charitable strategies as well. There is a strategy called the qualified charitable strategy where if you have qualified plans, you don't need all of it. Instead of paying taxes, if you give it directly to a charity, then the government will not count that as part of your income. Next slide, please. So we're coming down to the end, and I know we'll open it up to questions. So let me move through charities. Next slide. This is another mistake that persons tend to make in their overall estate planning. one of the things that people don't understand, and I know not everyone's always charitably inclined. You know, you drop some dollars here at the church every Sunday, but not a lot of people are giving, you know, huge sums of money at one time. But believe it or not, Americans, statistically, when you compare it to other countries, are very charitable persons. So even if you don't see yourself as really charitable, think of it anyway, because there's going to come a time in your life where you or someone you know will give more than you ever thought you could to a charity, whether it's your church or your school. And so how can you take advantage of that? Next slide. You can take advantage of that by being able to use techniques that will get the asset out of your estate, in some instances allows you to have access and use it, but then ultimately give it to a charity. So you see a lot of acronyms here: CRT, Charitable Remainder Trust; CLT, Charitable Lead Trust. I don't think that this is the space to get into all of the nuances of that, but what's important here is if I have a piece of property, let's say piece of property. Again, the Miami beachfront property, I'm using it as rental income property. It's generating $25,000 a year in rental income property. I can put that inside of a charitable remainder trust. By putting it inside the trust, remember that means now it's outside of my name, and I don't own it, and they can't tax it, they can't seize it, they can't access it. But I can still use it. I can still receive that rental income on an annual basis, and I'll just be taxed on the income, but not on the value of the property. And whatever's left when I pass away, the charity gets it. Now, this is really good for property that's going to appreciate in value. That Miami property is $800,000. But LeBron James comes into town, they build a new stadium, a new football team comes in, and now that $800,000 property is now worth $3 million. Guess what? That growth, that $2.2 million growth, that's not going to be my problem because it's not in my name. I'm not going to be taxed on it. The growth of the property is now officially outside of my estate, even though I can still use it by receiving income, rental income from the property on an annual basis. And then the cherry on top is whatever's left goes to the charity of my choice, and my estate receives a charitable deduction when I passed away. Next slide. Funding. Next slide. What does this mean? Well, it's really, again, going back to the cost-efficient transfers and the tax-free transfers. It applies to those persons who are going to find themselves with an estate tax bill. Next slide. And so always remember this. The federal government wants its money within 9 months of your passing, and they want it in cash. That's why you see estate taxes. I used to live in Montclair, New Jersey, and I would go through Montclair and I would go through Upper Montclair, real shishy places of New Jersey. And I loved it because I break for yard sales. I take it after my mother. I used to hate when she did it, and now I like it a lot. And not just any yard sales. I mean, I'm not trying to go through your trinkets and your, like, hockey figurines. I want to go to the estate sales. These are the people who are worth millions of dollars but don't have the liquidity to pay their tax, so now their family has to do a fire sale. So that's when you see the beautiful furniture out there, the furs, their house is now on the market, well undervalued. That's an estate sale. So when you see that going on in your neighborhood, that's how you know that's indicative of someone who has an estate tax problem but doesn't have the liquidity. Because, again, the federal government doesn't want your house. They don't want your business. They want cash, and your family is going to be left with the responsibility of finding out where that cash comes from. And so funding is the ninth mistake that persons make when estate planning. They don't set aside cash to say, okay, if I do my calculation right, they're going to come knocking and they're going to ask for $425,000. Okay, got it. Where does the $425,000 come from? Next slide. And so funding is all about finding ways to take an illiquid estate and make it a little bit more liquid so that your family has the money to pay your tax bill. Next slide, please. So, next slide, please. So one option to make your estate more liquid is to set aside funding and put it inside of a trust. So if I say, and I sit down with an advisor like Greg and myself who says, listen, we've crunched the numbers, we've ran your assets through the system, we think you're going to owe $425,000 when you pass away. We can use an annuity to pay that. We can use life insurance to pay that. But what we want to do is make sure that whatever that funding vehicle is, it's not owned by you. Because if you own it, that means now you're worth more, and we've just made your estate tax even bigger. Let's put it inside of a permanent, irrevocable trust that as soon as you pass away, the cash is put inside of that trust. And now when the IRS comes knocking, your family can simply write a check from that trust and pay your bill. You don't have an estate tax sale. You don't have to worry about people like me driving through on a Sunday afternoon and say, oh, that antique desk looks nice. I'll have that, please, and thank you. So funding and proper planning with the use of an irrevocable life insurance trust, allows you to make sure that your family has the liquidity to pay your debts. Next slide. Lastly, what's the next last common mistake? Next slide. Procrastination. And I put a whole bunch of question marks, and the reason I put that is because I have found that we procrastinate because we just don't know where to start. It can be overwhelming. Not only is this a sensitive topic because we're talking about death and the time we're not going to be here. A lot of us are type A controlling personalities who are busy, 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 and to think of a time where we're not going to be here is too much for us to bear, right? And because of that, we procrastinate. But if you can set up a plan and say, okay, this is my intention for the year. This year, I'll set up a will. Next year, I'll have specific instructions for my trust. By the third quarter, I'll have this. And take it off piece by piece. It will allow you to rest more easily at night. Because, as I said, it took me a long time to get my parents to do their estate plan. But now that they've done it, they're so happy and talk to me about it all the time. Now we have conversations about it when before it was too taboo to talk about it. The ice has been broken. The issues have been brought up. We already have solved the issues, and now it's a much more comfortable discussion. So I encourage persons not to procrastinate and to sit down with an advisor such as myself and or Greg to work out what is it that you're trying to, what goal are you trying to achieve? That's my job. You tell me what's keeping you up at night. Within reason. You tell me what's keeping you up at night, and I can tell you some strategies that people like you implement to finally rest assured. Next slide. Next slide. So we want you to act now because you have great resources right under your nose. I'm here in the New York area. My clients are in New York and D.C. Greg is here in the New York area, and I've been doing this for 10-plus years at this point. And so I can share with you what I'm capable of, what other persons have done and implemented, and then share that with you. And so it's good to have a second opinion, even for those who have thought about this and maybe ran it by someone and then didn't act. This might be your time to act. Or those of you who've had this discussion before and weren't really confident with the information you received, you can sit down with myself and or Greg to discuss, get a second opinion. You can have us, we can look at your documents to make sure it does what you think it does. You wouldn't believe how many times persons have paid money for a document, trusted that it did what they thought that it did, never really reviewed it, and even if they did review it, weren't sure what it said. Those persons have come into my office and said, I think this does A, B, C, and I would always say, this actually does X, Y, Z. If you wanted to do A, B, C, these are the changes that we need to make. And so act now because you have these resources right under your nose. I can share with you and Greg can share with you some really good strategies. And one thing I'll say in closing is, your biggest impediment to creating and passing on wealth is taxes. A lot of times people will come to me and say, well, Lillie, you work with affluent people. How are they so wealthy? How are they able to do this and do that? And I always tell them they take advantage of the tax code. They take advantage of instruments that will not be subject to tax. They put their money in vehicles that grow at 3%, 4%, 5%, 6% year over year and access it without ever having to pay ordinary income tax or even capital gains tax. That is how they are able to maintain and grow and pass on their wealth. If every dollar you make is being taxed at 40%, you are not going to be able to create and maintain wealth, not at a good rate, to say the least. And so if you're interested in growing wealth, maintaining your wealth, distributing it, and making sure it passes exactly the way that you want it to do, then that's where myself and Greg come in. Next slide. And I will end there and turn it over to Paula so that Paula can open it up for questions.
Hi, thank you so much for that very, very informative presentation to both of you. There are not any questions in the queue right now, so if you have questions, go ahead and use the question area on the dashboard, and I'll be able to read it to our speakers. If you have a question, ask it now. So that was very, very informative, and thank you for the energy and the information.
You're very welcome.
Well, while we're waiting for questions, I think everyone can get a sense of why I enjoy working with Lillie so much. Just in the past hour, I've become worth $7 million. I have a beach home in Miami. She loves me so much. She's leaving me everything, and she's doing it in a way that I don't have to worry about her having too much tequila tonight. So
I do think that one of those millions of dollars was mine too. So I think I'm good.
Well, I was going to say I'm going to need that back next month, Paul.
Okay, I have one question that just came in. It says, does the trust hold on a second. It says, does the trust pay the capital gains tax on the property as it appreciates in Miami Beach example?
No, because if I understand the question correctly, if I have a piece of property that's sitting inside of a trust, you don't worry about capital gains until the property is sold. So let's say in my situation, it is eventually sold and there will be capital gains. Yes, then at that point, the trust will pay the tax, or the trust can distribute that liability to the individual and say, hey, I'm selling this piece of property and I'm giving you the proceeds, the $2.5 million. You're going to owe 20% on that. You pay it. And it'll be better, quite honestly, for the individual to pay it because the individual tax bracket is lower than the trust's tax bracket. So as long as you keep it and never sell it, no capital gains. If you do sell it and you keep it inside the trust pays it. Or if you sell it and immediately distribute the proceeds to an individual, the individual pays it. Great question. Thank you so much.
That's all I have in the queue so far. So I'm going to give it another minute or so for any additional questions. Any other final sort of tips? If someone is sort of in the space and has done nothing, in terms of a first step, you talked about, 6 months, 3 months and breaking it down, but what should they do right now?
Right now, I would sit down with an advisor, myself, Greg, and talk about what your overall goal is. What's your objective? You haven't done anything, no papers, never sat with an estate planning attorney in your life. That's fine. Sit with us and say, let me hear about your family. What is it that you would like? Do you have something you want to leave to children, to charities? What's your net worth? What's the value of your home and your retirement plan, so on and so forth. And so based on you just telling me your story and you telling me what's important to you, myself and Greg can then point you in the right direction and say, okay, you probably need a will and a trust, or you probably need a will and a trust and to increase your life insurance, or maybe you don't need life insurance but you need annuities. So just tell us what's important to you and we'll be able to point you in the right direction. Okay, well, since another question didn't come in, I'll ask another one. How do advisors and attorneys work together to make sure that the client has the best estate plan? That's an excellent question. So you think of the attorney as the legal person that will put all of the papers together, cross the T's and dot the I's, make sure that the documents are filed with the right places, and it says exactly what you want it to say. The financial advisor will put the money, will wrap that up in a pretty pink bow, which will be the money, because a lot of times people have these really great plans either in their head or on paper, but they have no money to actually bring it to life. And so a financial advisor like Greg can come in and say, okay, we looked at the documents. Lillie has recommended that you do this, this, and this. The financial need is this. You need to raise an additional $300,000 to retire the way that you want. Or you need $50,000 to pay this tax. Or you said that you want to make a gift to your granddaughter of $100,000. These are the types of vehicles and instruments we can employ to meet that goal. So the documents will articulate the goal, and someone like Greg will make sure that the dollars are there to make the goal actually happen. And that's how he and I and most attorneys and financial advisors work together.
Yeah,
one doesn't supplement the other. I can't do Greg's job, and Greg can't do my job, so we both need to be at the table.
Perfect. So we're now at 2:30, and our promised time is 1 hour, and I want to thank you both for providing this information. Both Lillie and Greg's contact information is on the slides, and the slides are in the handouts of the database or the dashboard. They'll also be emailed to you along with a link to it for a survey, so you will have their contact information there as well, and we do hope that you'll give feedback about this webinar and suggestions for any additional topics you'd like to see. Thank you so much for joining MBBA Learns Common Mistakes in Estate Planning, and we thank our panelists one more time. Have a great day. Bye-bye.
Thank you.
Bye.